I think this session will take
We will have dedicated Q&A more.
yeah, we'll take a lot of Q&As now, especially with the latest updates, what happened.
Yes. We will have dedicated Q&A.
Yeah.
So I think, Praveen bro, let's get started.
Good evening, everyone. Thanks for joining. I know there is a lot of noise across the United States talking about the latest Trump's proclamation restrictions on H-1B. So this is definitely one of the interesting topics. Not interesting, but it's kind of making everyone worry. So we worked with our immigration, one of the immigration top immigration attorneys from the US, Bhanu. They kindly agreed to join us this evening to give some insights on actually what's going on. Also, we have our TTA leadership. Thank you, Navinana and other leaders for joining us today. Over to Navinana. Please briefly talk a little bit about TTA.
Thank you, Praveen. Sorry, I'm worried, but yes. First of all, let me thank Bhanu Garu for accepting our invitation. It's when Praveen called me last night, it was like late night, and we have to wake Kavita Garu and others too, just because this is such an important thing. And thanks to entire team for acting fast. Kavita Garu and Shiva, Deepika, Narendra, thank you very much, Jyoti Garu, for jumping in, and whole Phoenix team, because this is very important for today. This is the important topic for a lot of confusion employers as well as employees too. So thank you very much, Bhanu Garu, for accepting and jumping in. Thank you very much. Thanks, Praveen.
All right. Thank you, Navinana. Thank you. And Bhanu Garu, thank you so much for accepting our invite. Just to brief about Bhanu Garu's law firm. So Bhanu Garu is managing director and the founder of BBI Law Group, one of the top law firms in the United States. I would definitely say that proudly. And Bhanu Garu is always a go-to person for any issues related to immigration, and he does a lot of immigration related, business immigration related, and immigration related. He handles a lot of big cases, and he's very prominent in employment-based immigration, family-based immigration, EB-5, I-9 and E-Verify compliance, naturalization matters. So, Bhanu Garu, thank you so much once again for joining us this evening. And over to you, Bhanu Garu. Just talk to us about what's actually happening. So, what this proclamation restriction is about, and it has created a lot of panic amongst all the H-1B holders in the United States. And so, how to handle this situation, and do we really have to worry about it? And the people staying in the United States versus whoever travel, who are in the transit. And over to you, Bhanu Garu. Please help us understand what's going on.
Thank you, Praveen, and thank you, Naveen Garu, and making me part of the organization today. And it's a need of the hour and very timely connected session, this one. And just want to let you all know that whatever we discuss during this call is meant for general awareness purposes only. It does not constitute legal advice or create an attorney-client relationship. At the same time, neither us or a TTA should not be held responsible for any actions taken by all individuals by listening to this call. I think it's always better to discuss with your attorneys as well, or to us privately also, if you want to discuss anything about your private matters and anything like that. But overall, in general, what we would like to bring attention to this is with the President's proclamation order pertaining to the restricting H-1B workers and the requirement of paying $100,000 fee by the employers for each H-1B petition is almost chaotic in nature, because it's going to create a huge problem for the employers to pay their $100,000 fees for each H-1B employee. And the situation is whether this fee will be applicable to everyone, every petition, and what to be done, and with the cases that have been pending. All these questions, all these confusions have happened. But now we have a clarity after 24 hours of this proclamation order has been passed. And there are a few more hours for this proclamation order to come into effect. And we have a clarity to a certain extent right now. But still, we do not have a clarity to many issues, but we have a clarity. The first clarity is the proclamation order clearly says that it is not applicable for the individuals who already have an H-1B visas and who are traveling abroad and they're trying to come into the country, or who already have applied for the visas and waiting for to get the stamping done for those visas. And also the $100,000 fee will not be applicable for the individuals whose case are already pending with the US, filed and pending with the USCIS. People can travel, people can come in. There are no restrictions for that. That is one good relief right now with this update which has been given by the USCIS and also CBP. Both of them have given these updates recently, and they clearly say that these individuals are exempt. So any individuals who have an existing H-1B petitions, they'll be able to stay in this country. And any individuals who have an existing visas, they should be able to travel freely and come back. And who applied for a visas already, they should be able to attend the interviews and see whether those people will be given visas or not. We have to see that. So that issue has been clear. But what issue is not clear is there is a conflicting information pertaining to the requirement of $100,000 fee for what type of cases employers are required to pay. And also clearly said that, and this memos also clarified on certain issues and did not clarify on certain issues. There is a conflicting information in the memos issued by the CBP as well as the USCIS. These memos have come just 1 hour, 1.5 hours ago. So a lot of people may not be aware of them or might have not gone through them also. But we posted in our WhatsApp groups. You guys can, you all can access to those memos from our WhatsApp groups. The USCIS memo says that obviously this fees is not applicable retroactively for any cases that have been filed prior to the September 21, 2025. The fees will be applicable to all the petitions that are being filed on or after September 21, 2025 for the individuals who are seeking entry into the United States on H-1B visa. But it does not differentiate whether that fee is applicable for extensions, transfers, change of status petitions, or new petitions. And that is the problem I have with the interpretation with the memo issued by the USCIS. Whereas the memo issued by the CBP, they confirmed that this memo, this proclamation is not retroactively applicable. It's only applicable from the day it has been coming into effect, and also clearly states that this $100,000 fee is applicable only for the cases for which individual is outside the country, for which the employers file an H-1B petition outside the country. But USCIS memo does not clarify that whether this fee is applicable for each petition filed by the employer who is already within the country. And second thing also is during the proclamation order or during the press briefings yesterday, day before yesterday, they were saying that $100,000 has to be paid annually on annual basis for each H-1B worker. But now it says that it's only one-time fee. It's not applicable for the renewals or extensions or anything like that. So that is one confusing also what happened from yesterday and today. We have a clarity on that this fee is not applicable, is not required to pay on annual basis. We only have to pay one time at the time of filing for a new H-1B petition for the individuals who are outside the country. That's what we have to assume based upon the CBP memo and the comments made by the press secretary of the White House and various other individuals pertaining to this proclamation order. But this is the confusion we have right now. If by reading clear language of the USCIS memo, if you want, I can post those memos over here, but you can all can read that, and which can really make you understand what I'm trying to explain with those memos over here, you know, and so that is what it is. So people who have an existing visa, yes, they can travel, they can come back. But people who don't have an existing visa, I would still tell them not to travel. I would still tell them to hold on to their horses, stay here until we have a complete clarity on how these things will go, because we're expecting potential lawsuits also being filed on this particular case also. So those are the things which I really want to bring it here, Praveen. Summary is most of the people we know way this proclamation is coming in, uh, making it more difficult and hard to access H-1B program for the small employers. And that's what my point of view if it comes to this proclamation order.
Excellent, and it's definitely a great sigh of relief for a lot of H-1B holders that are living in the United States and who already got their visa. So I know, again, what do you suggest, like just in case someone is really willing to travel due to some family emergency, do you see any challenges coming back or?
If they have a visa, they should not have any problem in coming back. And people who already have a visa stamped also, who never came into the United States also, they should also be able to come back based upon the latest information provided by the CBP and the USCIS also, you know. And so I don't see any problem for them traveling to the United States.
So what about the H-1B petitions that are already approved where they are in India but not go for stamping? So
Yeah, even for them also, the fee is not applicable. What they said is the fee will be applicable only for the cases that are going to be filed on or after September 21, 2025. Because these cases are already filed and approved, so they can go for the stamping and the fee is not applicable to them.
Okay. Great. I think, yeah, that's definitely a great sigh of relief for
Yeah.
a lot of people.
Yeah.
And also, this proclamation talks about potential exceptions, right? Exceptions or waivers. Can you talk a little bit about that?
Yeah. The exemptions, what the proclamation is talking about is that if the employer will be exempted paying $100,000 fee payment if the employer can establish that bringing in this individual on H-1B visa is of national interest or of an economic interest of the nation, then those waivers can be considered on a case-by-case basis at the discretion of the USCIS and the Department of State to issue the visa for the individuals, to approve this petition and everything.
Got it.
So,
It's a national interest exception, exemption.
yeah.
So, just for the general awareness, can you talk to us a little bit about what types of cases are exempt? What
Okay.
type of situations?
I mean, so for example, during COVID, the doctors were basically treating the COVID patients over here and they needed more workforce. So they were qualified for the national interest exemptions at the time and they were able to get the visas and able to come into this country, healthcare workers and primary emergency workers and everything. In that way, if somebody is a part of any research which is of utmost importance to the United States government, those people may qualify, for example, So it's a very case by case basis, very difficult for us to really assess to the aspects. We have to look into all those factors. See, the most important thing which I'm worried about is how this is going to impact in hiring of the H-1B workers, right? That is what is worried about, right? And so that's where the whole problem comes in. And we had a lot of confusion. It's a one pay every year you have to pay. That means you have to pay $300,000 for 3 years of an H-1B individual, or it's a one-time $100,000 for H-1B individual. Those are the questions we have, right? Now we know that the petitions that have been already filed that are pending with the USCIS, this 100,000 fee is not applicable. And USS clearly says that this fee has to be accompanied by the H-1B petition filed on or after September 21, 2025 with the USCIS. That means USCIS will likely or may likely reject the application if it do not include this $100,000 fee if you're filing an H-1B petition. And the problem here is why I'm concerned about that is, as I said, USCIS memo does not differentiate whether it's a petitions filed on behalf of the individuals who are outside the country or who are also in the country. That means if you're filing for a change of status or if you're filing for a transfer of an H-1B petition or extension of status or an amendment, do they all require to pay $100,000 fee prior to them accepting this application? That is the confusion we have with the language in the memorandum issued by the USCIS. But that language in the CBP memorandum issued by the CPP is clear. They're saying that the $100,000 requirement is only for the people for the new petition that are filed on behalf of the individuals who are outside the country. Okay, so that is the concern which we have. Every lawyer, we are worried about whether it's applicable to all the cases or will be applicable only to certain set of cases, right? With the CBP, with the press secretary comments, we know that it's applicable to only certain set of cases, right? But with the USS language, it's very confusing. Now we have to see how much chaotic it will be with the USAs in coming next few days, how they will sort out this one, how it will go out. All these things we have to see. So we will be filing cases this coming Monday, and we see what happens. Whether they will accept those cases, they will return those cases. We will have an idea.
Sorry to interrupt. Sorry, I just need to talk to Kavitaka. So looks like we are not able to allow more than 500 people. So is it the max limit? Yeah.
I think Kavitaka is not available, Praveen Garu. Deepika here. నేను యూట్యూబ్ లింక్ షేర్ చేస్తున్నాను, లైవ్ లింక్, సో దట్ వే
Yeah, please share that
maybe
in
for
the
now. Yeah,
chat as well, and maybe
just
read over.
couple of minutes. Yeah, I'm going to share it right away. Yeah.
Perfect. Thank you, Deepika.
Thank you.
Yeah.
So yeah, I think in your opinion, is it kind of what do you think about? I know like it's kind of a weird question, but do you think like courts might interpret the presidential authority to impose such a fee, or what do you think about it? Like,
See, I mean, INA Section 212F has given a broad authority for the president to determine who can come into this country or not. But the issue here is whether this $100,000 fee is actually a tax, okay, to hire an individual. Because on what basis? It cannot be a fee in the form of a fee the USCIS cannot collect, because that power is vested upon the Congress. President cannot issue that kind of an order. It has to go through the Congress. Congress has to pass the law, and then it can be implemented by the USCIS. So only the way president can impose this is that if he's basically considering it as a tax for this thing, and that is the argument. You cannot impose a tax to hire somebody in this country, right? And also, if it's a tax, that is also in the it's a power. It's actually the power of the Congress to pass the taxes, what to determine what taxes to be implemented, what taxes not to be implemented, not the president's. I think most of the lawyers are looking to the aspects to sue the government based upon this issue, whether this can be argued as if it's imposing tax on the employers for hiring and this H-1B workers, because it's a one-time $100,000 fee payment they have to pay to hire an H-1B worker. And very likely we will see a lot of lawsuits being filed by many organizations. But how soon they'll be filed, how it will be filed, when it will be filed, that will only be known when we know that there are certain affected parties who are willing to become plaintiffs in these lawsuits and be part of that. And when larger organizations like Chamber of Commerce and other organizations involved into these lawsuits as an MECs, then I think we'll have a very good strong argument what courts will do on these issues. If they make an argument like if it's a tax imposition by the president without a congressional authority, congressional involvement, probably it's likely that that can be stricken off in the courts. But whether the court will determine it as a presidential power under 212F, other president has an authority to impose such kind of a fee under 212F, or will consider that as a tax, that is the arguments which we have to see in the court. I think that is one which I'm really worried about it. See, this is not which I'm telling. This has been actually, if really this AI times, if you look into, if you do this analysis in AM or AI, open AIs like ChatGPT or Grok or some other things, they'll give you the same analysis to you, what I said to you. Because that's only the way I think this issue can be fought in the courts. I think they will try to do that. Because now, because of the emphasis of the courts, how they're given in the presidential authority under Section 212F in recent immigration matters, I think the only way anyone can try to win this case is through these probably this is the process. Say, I'm not a litigator, so I do not want to really comment other than that. But this is only the possibility which I'm seeing based upon my knowledge.
Great insights, Bhanu Garu. Thank you so much. And I know like a lot of business owners and employers are also there in this call. In the interest of the business owners, like I just want to understand. So do we think like business owners should start changing should they do any paradigm shift like strategic planning of new opportunities to
Absolutely.
consider any alternatives?
Absolutely. Absolutely. That's a great question, Praveen. Really great question. Really appreciate for asking that question. And I would say yes, because the reason why I would say yes is although they say this proclamation is for 12 months, but they have a discretion to extend it beyond 12 months, right? And if they do that, it's likely that during the cap season, you may not be able to file any cases uh, for the individuals who are outside the country, right? And majority of the cases will be filed during the cap. And the other thing is, if they're subject to this to every H-1B petition by the USCIS, which are filing after September 21, 2025, because of the way the language in the memorandum is stated, although it's conflicting with the CBP. And see, these are all the factors we can play in litigation, saying that all these agencies have a different policies and different regulations, different guidance, which is basically confusing and chaotic. Therefore, we can also make that kind of an argument in the lawsuits, but that's a different thing. So, with all these things going on, I think the employers should find the ways strategically how to make sure they have their intact workforce so that they can continue their businesses. They can look into the options like O1s, how O1s can be utilized during these times. It's very, very important. And also L1s also. L1s will be a very good a basis for them to utilize these times by establishing offshore companies and developing, breeding the workforce over there. And then once the workforce is bred or grown over there, bringing that workforce into the US, I think is very, very helpful for them with these programs, with what's going on. With the current administration, the hatred they have against the H-1B program, what's going on with the H-1B program and everything right now. I think it's a great strategy, great questions. At the same time, probably we may have to see importance of hiring or providing training to the local workforce also along with these things, and see how we can develop them to the competency level which we get from from the foreign workers, the high level skill what we get from foreign levels from the domestic workers also. It may take several years to do that, but I think employers should make it as a part of one of the strategical way of doing these businesses, especially small companies, because I'm not sure. Big companies might take a hit. Sometimes they may be okay to pay that $100,000 addition per one time for an individual if they think that individual is very, very important. But small companies, I think it's like a completely, basically the program is being now giving access only to the large companies, large corporations. And they're basically taking out the access to the small companies, this H-1B program. That actually may have another indirect impact on the wages of the employees also now, because there is no competition of employer or a hiring for these individuals by the small companies. So these big companies can dictate the wages and they can drive down the wages way low. Actually, it may work in opposite what the current administration is thinking, but we are not in their ears, so we cannot really guess what they're thinking and what they're doing and everything. But that's the future which I'm seeing it, because the access will be given to the large companies and they can actually drive down the wages, and they may be inclined to get more cheap labor because they're paying 100,000 advance to the government. They can demand the worker saying that you have to work for cheap for us. That's where it's going to happen, because it's a capitalistic world. Nobody is going to pay money holistically for anything here.
Excellent. So yeah, I know it's a great relief for existing H-1B holders, but again, like students like OPTs and in transit, like meaning whose H-1 got picked and not yet filed, I think they are going to have a really tough time convincing their employers to pay that $100,000.
Yeah.
Unless they are like super rich employers like Amazon, Facebook, and again, niche also matters here, right? Maybe right now it's a need of the hour that everyone has to upskill and make sure that they meet the demand where like the employers are ready to pay $100,000. Otherwise, practically it's not gonna be possible for someone to pay 100,000 just for one petition, right? If they're filing like 100 petitions, like what? Wow. It's in millions.
No,
So
it is $1 million right there.
yeah.
I
All
mean,
right. And
$1 million.
yeah. So far, great insights. And I think like we have over 100 questions waiting in the queue.
Sure.
Now I'll let Avinash, now that like we have discussed, already covered a lot of topics, let's try to avoid the duplicates and ask only unique questions from we are opening it to public now. Ask any questions in the chat box. Okay. Avinash, over to you.
Yeah, I think Bhanu Garu, one thing, if you can repeat about the existing H1s and because a lot of questions I think are thematic about existing H1s and H1 transfers, and if they can travel to India. So probably if you can spend just like a minute to address that again, we'll cover a lot of questions about.
Yeah. See, the proclamation will be applicable only for the petitions that are filed after September 21, 25. So any petitions that are filed prior to the September 2021, 25, they are not subject to the $100,000 fee payment. That means those individuals can go for the stamping once the petition is approved if they're outside the country. Okay. And if they're within the country, they are okay. They can travel, they can basically stay, work till the validity of their H1B petitions and everything. And if the change of status is pending, the change of status also will be approved without any problem in the US. And if they have existing visas, they have the valid visas, they should be able to travel freely and come back. And if they don't have a valid visa, they can still go abroad, apply for a visa, and then enter into this country as long as they can show this petition was filed prior to September 21, 2025. Okay. Only the people for whom you file petitions on or after September 21, 25, then this $100,000 fee will be applicable. The discrepancy here with the USS memo and the CBP memo is that CBP memo is saying that that fee is applicable only for the petitions that are filed for the individuals on or after September 2021, for the individuals who are outside the country on or after September 21, 25. Got it? I think I confused the statement over here. What I'm trying to say is CPP memo clearly says that the $100,000 fee payment will be applicable to the petitions that are filed on behalf of the individuals who are outside the country after September 21, 2025. Okay? Whereas USS memo does not provide that clarity. So we have to test the waters. We have to file some change of status petitions. We have to file some transfers, and we have to file some extensions in the country and see how they will impact, how they will work on that and everything. Probably we'll have an idea in next 3-4 days how they're going to react on those cases, because we'll be filing few change of status application petitions and few extensions, few amendments, or few transfers in Monday, Tuesday, Wednesday. So we will know whether they will accept those cases and issue the receipt or not based upon that information. We'll be able to provide again an update to our community, and basically we can see whether we can have a sigh of breath of relief or not. See, if it's only for the new cases filed after ANA September 2025 for the individuals who are outside the country, then I'm not too much worried, because this year cap is already over. So this year cap is not impacting with this. Only it's going to impact the coming cap and coming future petitions that are going to be filed on behalf of the individuals outside the country. You can only file petitions who are outside the country are 3 types of people, right? One is who are subject to the cap. Other one is who are cap exempt individuals. And the third one is who are already counted towards the cap and who are outside the country.
Okay, I think that clarifies a lot of questions here.
Yeah, so these are the 3 types of individuals for whom you can file the petition. And so most of them, they will be on the cap side. So that will be only impacting the fiscal year 2027 cap, for which you'll be filing in April, May, June, July next year. So that is something which I'm really worried. See, what really, before the call for 30 minutes, I went almost blank because of this discrepancy in both the memos. The memos issued by the USCIS and the memo issued by the CBP.
Okay.
Yeah.
I think a couple of questions are also coming from H4s. So is there any impact at all for any of the H4 petitions or their travel plans?
No, not at all. See, only the people who are impacted with this are the H1B holders only H1B visa holders. It does not impact H4s, does not impact L2s, does not impact F1s, does not impact O1s, does not impact Ps, Js, Ms, or any other non-immigrant type visa categories. This proclamation order only impacts H-1B workers.
And if somebody is in a situation where they lost their job right now and they're on H-1B and grace period of 60 days, and they would find a new employer within 60 days, is there any impact for such scenarios?
See, that is what I'm saying, right? Because of the clarification we do not have with the USCIS, if they require everyone, for every petition you file, new petition you file, you have to pay $100,000, right? The new petition means it's a new petition or a change of status petition. Usually, change of status petition or a petition for the individuals who are outside the country are considered new petitions. Transfer of a petition, extension, and amendment may not fall into these categories. Okay, so in the question scenario, what you asked is probably it may fall under the transfer of an employer situation. Probably we may not have to pay $100,000 fee, but the memorandum with the USCIS, what US has issued, is really confusing on that, you know, and that is why I'm not able to give you a concrete answer saying that it is okay for you right now, because we will know in next 3-4 days once we file those cases and see whether they require us to pay the fee because or not. Because when you're a grace period, when you're filing for another employer, it's a transfer of an employer. But I'm worried about when you file for a change of status petition, right, in this country, because that's a new petition. Because it's a new petition, well, they basically ask you to pay $100,000 fee for that with the USCIS. Not only for the individuals who are outside the country, but even if you're within the United States also, because you're filing a new petition, will they ask for $100,000 for that also? CBP memo says no for that, but USS memo doesn't clarify that. That's why I'm a little bit worried about that. So, but we'll have a clarity on this issue next 4-5 days.
Okay, thank you so much, Managar. So the next theme that we are seeing is about F1s. So we have a couple of questions where they say they are currently in F1, they got their H1s picked, and the current processing is going on. So I would imply there would be no impact for such petitions.
Fortunately, there is no impact for them. Based upon both the memos, with the USS memo and the CBP memo, there is no impact for them.
And if an F1 student is going for, who's currently in OPT, is going for the lottery system next year, that is, which starts in March of next year, do we have any clarity on such petitions yet?
See, that is where I discussed till now, because if it's a consular processing, then yes, it will have an impact. We have to pay $100,000 fee payment with the CBP memorandum, or with the understanding of the proclamation order also, right? And also the statements made by the Caroline Leavitt, the press secretary also. But if it comes to the USCIS memo, there's no clarity there, because it will render either a change of status or a consular notification. Do they require us to pay $100,000 for it? Because it's a new petition. Because you have to click new employment in the H-1B petition in Form I-129, which is basically the basis for the H-1B petition you are filing. So because you check new employment, then they immediately say that you have to pay $100,000 for that. That is a question which we have to have worry. But the good thing is we have 3 months time for him or 4 months time for him to have this clarity on this issue. Okay.
Absolutely. And I think a lot of people are asking questions about traveling to India for extensions. Bhanugar already mentioned that there is no impact for an existing visa.
Existing petition holders, yeah.
Yes. And moving on, give me 1 second. There's the same questions are being repeated, so we're trying to filter them as much as possible. So we have a person who asked about that. He currently received a NOID on his H-1B application due to USCIS not accepting a digital signature from their employer. And his attorney is filing a new application again under consular processing currently. And they withdrew the old petition. But he has to travel out of the country. So will he need to pay 100,000, or his employer need to pay 100,000?
Did they already filed it, or they're filing it?
They're filing it.
If they're filing it, probably he may be subject to the $100,000 fee.
Okay.
because it's a council processing petition. So very likely that they may say that he may be subject to the $100,000 fee.
Okay.
If I were their attorney, I mean, I should not comment what other attorneys have done, but if I were their attorney, I would have not withdrawn that NOID response. I would have responded to the NOID, and then I would have filed this H1B along with it, and in premium processing, and would have sought approval for that, explaining the reasons why I'm filing this new petition. And under those circumstances, we got approvals.
Okay.
Okay.
And yeah. So what would happen if somebody got picked in the lottery and they're planning for a change of employer currently through the process?
As I said, change of employer is like a transfer of employer. So technically, I mean, with the language of the proclamation, with the press secretary comments, or with the language in the CBP memo, this $100,000 fee should not be applicable to them. But only the discrepancy is with the USCS memorandum, and it does not clarify on that. And for us, the cases which are the body that adjudicates our petitions are the USCIS, not these three people. So I'm a little bit worried how USCIS will take these petitions, and whether they require you to demand due to pay $100,000 fee for every petition you file with them after September 21, 2025, or only they will look into the petition saying that if it's only consular processing, then you have to pay $100,000. Or if the individual is outside the country, then you have to pay $100,000. Okay. So those are the three aspects which I want to really look into it in coming months. We will test the waters because now they issued the memorandums. That means they are ready. They are ready to go ahead. They're not going to make any changes to this. Maybe they may provide more clarity on this because there's a discrepancy in CBP and USCS memo, but we will hear that. If we hear that, we hear that. Otherwise, we don't hear anything from them. So only the way it can happen to us is by filing these petitions, and which we will file anyway in Monday because we have cases pending in our office, and we will have a clarity exactly what's going to happen with them.
And is there a different scenario for a first time stamp versus like first time going for H1B stamping versus going for an extension stamping?
No, I mean, what they said is if the petition is already approved, and if the petition is already approved, then they're not subject to this $100,000 fee payment. They can go for the stamping for those also. Those individuals also can go for the stamping. Okay. Uh, if the petition is filed after September 21, 2025, and if they're going for the stamping, probably they need $100,000 fee payment, but not for the renewals and not for the extensions.
Understood. And also, there has been a few questions about wage level changes. So have you gotten any notice about wage level changes currently, or has there been any increase for wage changes for H1B?
No, because they have to go through the regulatory process for that. They just can't increase the wages just like that because it's not up to their whim. They have to go through the regulatory process. They have to go through the uh, regulatory process. They have to go and look into the data and everything, see what the wages are incommensurate in the market and what they're prescribing and everything. Because if they prescribe the wages which are not incommensurate with the market rates, they're going to lose it. They lost it in 2019. They tried to do that. And so the same thing they're trying to implement right now. So they have to go through the regulatory process and everything. So Department of Labor, Secretary of Department of Labor made an announcement saying that he's going to work on, they're going to do these changes, but we do not know how soon they're going to implement these changes, how soon they're going to make announcements pertaining to these wage levels be changes, because they're going to change the wage levels, right? Now we have four levels of wages: wage level 1, wage level 2, wage level 3, wage level 4. This is the wage levels prescribed by the Department of Labor. We have alternative wages also. We use alternative wage surveys all the time in our office to file H1B petitions because those are the wages which are basically bound by the unions or collective bargaining agreements or private survey agencies also, basically, right? A lot of private entities in the particular industry uses those wages. Based upon that, we determine the wages. So USS do accept those wages also. So now they're going to change these wage levels. Are they going to keep four level of wages, or are they going to keep only median and above wages, right? So those are the things which we have to look into. And most likely it is going to increase the salaries for the employees. Base level salaries will increase probably around 20 to 30% or 35%, I would say. Not more than that though. Okay. the base level salary will increase, and then and the skill level also. What they say that they have to look into the skill level also of the individual by the USCIS. But for Department of Labor, it's only wage. That's what they look into it. And also at the same time, they also uh, uh, directed the Department of Homeland Security also, saying that they have to, when they're implementing the cap for the next year, they have to consider the skill level and the wages offered for the employees also. Higher wages, higher skilled individuals should be given priority in the lottery selection process. These are the two important things mentioned in this proclamation order. But nobody discussed about that because we know that that's going to happen, because that announcement came long time ago about these two things.
Thank you, Bhanu. And also, there has been one theme that's going on about getting stamped across other countries in Mexico, Canada. We have at least
They
three
can't go.
questions.
They can't go because that's been done, right? They already made an announcement saying that from September 2nd onwards, from now on, from the day that notification has come from the Department of State, they cannot go to third party countries. They only have to go to the countries where they are a national or a permanent resident in those countries.
And I see a lot of questions about premium processing. I think those are case by case. Probably better to have a individual consulting for that. A lot of people are asking about if there is a change, if we go for premium processing for existing change of status or any of the extensions that have been filed, would there be any difference compared to the regular processing?
No, because as I said, already pending case does not make a difference, so it's up to them. See, I mean, it's about your situation. If your situation warrants expedited processing so that you will not lose your job opportunity or anything like that, then I would advise you to go for the premium processing. Or you just want to have a psychological relief saying that your case is approved, so you'll be safe in situation, go with the premium processing. Okay, so it's an individual's preference whether to do it in premium processing or not. And some companies need certain individuals on expedited basis because of the time is of the essence for certain projects and everything. So under those circumstances, people will prefer filing in premium processing. So if you want to do premium processing and if your employer is willing to file that in premium processing, go ahead. Don't waste time.
I'm sorry to interrupt. So I have been receiving a lot of text messages asking few questions directly, but
Yes.
I'll take one of them. A lot of people are asking about H-1B transfers. I don't think like we have any impact for H-1B transfers. Still, like people can move between the employers, right? Existing ones.
That is where I have a problem. That's what I'm saying. That is where I have a problem with the USCIS memorandum language. Okay.
Okay.
USCIS memorandum language does not differentiate any petitions that are being filed after September 21, 25, whether for the individuals who are outside the country or for the individuals who are within the country.
Okay.
Right? So that is what really bothers me. Whereas CBP memorandum clearly says that that fee will be applicable only for the individuals, only for the petitions that are filed on behalf of the individuals who are outside the country.
Right.
Okay. So that is the worry which I have. That's the reason why I was insisting from the beginning. This is the clarity we need because of the discrepancy we have in these two memos, and how the USCIS will interpret this memo, how they will implement this memo is really bothersome right now. So only the way I will be knowing it is by testing the waters, by filing few cases on Monday, which we will do.
Okay. And H4 and H4 EADs as such will not be impacted by this,
No,
right?
they're not impacted at all. H4s and H4 EAD is not impacted at all.
Okay, thank you.
Okay. And Bhanu Garu, is there anything different if a person is working for, let's say, a non-profit state or any of the government offices?
No, that's what I'm saying. It does not differentiate whether it's a cap exempt H1B employer or a reg cap subject employer. You know, whoever it is, if it's a new petition that is being filed on behalf of the individual outside the country, as per the CBP memo I'm talking about, I'm not talking about as per the USCIS memo, as per the CBP memo, then the employer is required to pay one-time $100,000 fee payment prior to the filing of an H1B petition with the USCIS. Okay. And that's CBP memo. USS memo also says the same thing, but it does not say only for the individual who's outside the country. That is the whole problem I have here.
Okay. And is there and a couple of people are asking about a 6-year cap. So is this anything different for somebody who completed their 6-year cap having a 140 approved
No,
versus somebody who doesn't have a 140 approved?
no, it doesn't. I mean, if the individual is outside the country, you're going to pay $100,000 fee payment, irrespective of whatever it is. Only the point is, if you're in the country, what we are worried, that's what I'm worried about, right? Whether we have to pay that 100,000 fee or not, we don't have a clarity right now because of the way the language was stated in the USCS memo.
I have one more question for I think three people asked the same question. So what happens because say right now I'm on H4, earlier I was on H1. So if I want to go back to H1, so does the new rule apply to that, or is it still
This is where I give you the clarity. It's a change of status petition from H4 to
right?
H1. And with the CBP memorandum, no, this fee is not applicable. Okay,
Okay.
this fee is only applicable when you file a petition who's outside the country and you're trying to bring him back into this country. That means if it's a consular processing petition, then you are subject to the $100,000 fee with the CBP memorandum. With the USCS memorandum, we don't have that clarity. And that is concerning for me. That is even more concerning for me right now. With the change of status applications and the new petitions, new petition means change of status applications, right? Or the new petition means the petitions you're filing for the individuals who are outside the country, right? These two both are considered as new petitions as per USCIS. Some even the transfer also considered sometimes as a new petition by the USCIS.
Wow.
Okay, because you're paying the entire fee for that.
Right.
That's why. And so those are the things which I'm a little bit more concerned, with the language, how it's been stated in the USCIS. Hopefully, they will provide the clarification on this very soon because of the conflicting information provided in the CBP memo by the press secretary, Karen Levitt, and everybody else. So let's hold on to it. Let's test the waters on Monday. And hopefully, the scenario what you talked about, when you file for a change of status petition, if the individual is in the US from H4 to H1, then we may not require to pay $100,000 fee because we're not filing for the consular processing as stated in the proclamation and also as stated in the CBP memo and also as stated by the press secretary of Caroline Levitt.
So what happens to the documents that were sent last week, maybe because of any missing document? If USCIS is returning those documents, again, it will.
Then the case is not properly filed. That means that case is being filed only after September 21, 2025. Then that will be subject to the new fee structure, new fee requirement.
And I think we
Over to
have,
you, Avinash.
yeah, so we have one more question from our group. So an individual who's abroad with an approved I-140, a valid visa stamp, but whose prior H-1B was revoked and is now seeking a new petition through another employer. Would they have any impact?
Probably, yeah. Probably because he's not subject to the cap, but point is he's outside the country. So when they're filing a petition, it will be consular processing. So the government may say that you're required to pay $100,000 because you're trying to bring somebody who's outside the country.
Okay.
Although he's not going through the lottery, he's not subject to the lottery, but he's just outside the country. And they're filing a petition for him.
Okay. And is there an impact for change of status for L1, L2s to H1B, Manuel?
As I said, whenever change of status petition is being filed, irrespective whether it's an L1 or H4 to H1B, it is a new petition, and because of the lack of clarity in the USCIS memo, it's very difficult for me to answer that no, they're not impacted, right? If it's based upon the language in the CBP memo, I would say they're not impacted. But with the language in the USCIS memo, I cannot say that they're not impacted because I do not know how USCIS will interpret, how USCIS will exercise or execute this particular policy pertaining to the $100,000 fee payment if it comes to these change of status petitions.
Okay. I think we'll get more clarity in the coming weeks or probably in a week from now about this change.
Probably within 3-4 days, because we'll file in Monday. So we'll have an idea by Tuesday, Wednesday, because we'll file some of them in premium processing, some of them in electronically. So we'll have an idea.
Yeah. Okay. And the other questions are like one last question. So I-94 is getting expired on September 1st. So, there's so many questions that the question is actually moving up faster. So I-94 is expired on September 1st, and the current H-1B extension is in progress.
They're
And
okay.
they're okay. Okay.
They're okay.
And I think a lot more people who are asking questions about traveling. I think for existing petitions, you are fine. That question has been answered already. So you should be okay to travel for that.
Yeah.
And anyone who's waiting on an update for I think a couple of questions we had about 220G, Bhanu Garu. So anyone who's waiting on a status update for an existing application and they have a 221G,
They're not impacted.
they are not. Okay, because it's still treated as an existing application.
Exactly.
Okay, great. I think on an overall thematic is that we'll have more. We have a lot of questions mainly about change of status. Let's say L to H or H4s to H1s, and even some of the B1s to H1s. As you said, we might need more clarity from USCIS in the coming 3-4 days.
Yeah.
And then we could answer a lot more questions.
Yeah, because I mean, I read that memo 2-3 times, and I could not conclude that it is not going to impact all types of petitions that are going to be filed on or after September 21, 2025. So only the way I can only come to a conclusion after filing few petitions and see what USS will do with them.
Okay. There are also follow-up questions on asking if we will have another session once we have clarity about 3
I would
to.
love to. I would
Yeah,
love to
I
have
think
another
like
session.
it is definitely required, Bhanu Garu.
Yeah,
So
yeah.
within 10 days, we should have a follow-up session so that like we can keep everyone appraised about the latest progress that we make by then.
Absolutely, absolutely. We should. I mean, I'm very. I think it's my responsibility also to be part of the next call under the circumstances, because otherwise, it's like I'm providing off information to them. I'm not doing right service to them, because this is mainly meant to do whatever we can do to help our community, and it's not fruitful otherwise what I've done. So I really want to make sure that whatever we do it right way. And we have to do another session. Actually, I wanted to tell that to you guys that we should do another session in next 1 week, 10 days.
Very inspiring, very inspiring. Thank you so much, and your service to community is greatly appreciated.
Yeah.
Thank you, Bhanu Garu.
Thank you, Praveen Garu. Really appreciate it. Thank you, Naveen Garu. Thank you, entire TTA board, TTA, everybody in the TTA. Always been wonderful being part of the TTA, and thanks. I mean, let's keep doing more informative sessions like this. Immigration, various. I know TTA has been very active in all the topics and every area, and probably one of the best organizations right now in doing service for the community. And keep doing whatever you're doing, and all the best. And you all have a wonderful day. So good news is that people who are traveling, not to worry. If they have existing visas, they can travel, they can come back. They have no issues for them. If your visa application is pending with the USCIS, because your petition is already approved, you can attend for the interviews, apply for the visas, and then come back into this country. That is not a problem at all. And at the same time, if you are filing for a renewal extensions or amendments, you should not have any problem. If you're filing for a transfers also, I'm hoping that you should not have any problem. But these are the things which I will be giving more clarity and clarification to you all. And just let's hold on to our horses for a few more days, and we'll have complete clarity on this. Thank you all. Have a
Thank
wonderful.
you so much, Bhanu. Have a good
Thank
evening.
you so
Thanks
much,
everyone for
everyone.
joining us tonight.
Thank you,
See you next time.
Bhanu.
Thank you.
Thank you,
Thank you.
Praveen, and thanks to each and everyone.
Thank you.
As
Thank you,
Bhanu
Navin.
garu,
Thank
as
you
you
for
said,
letting us do this.
yeah, we have to finish this one. Let's have
Yeah.
one more webinar.
Yeah. Yeah.
Definitely,
Thank you.
definitely.
Thank
We'll
you.
do one
Thank
more
you so much.
follow-up webinar. Yeah.
Thank you.
Thank you so
Thank
much, Bhanu. Thanks, everyone. Have a good night.
You too. Yeah. Bye.